I'd like to call this meeting of the Standing Committee Resort Stewardship to order and welcome everyone in attendance. My name is Garth Rosal, MLA for Vermilion Lloydminster Wainwright and Chair of the committee. I'd ask that members and those joining the committee at the table introduce themselves for the record. We'll begin to my right.
Taney, Fort McMurray, Wood Buffalo.
Nolan Dick, MLA for Grand Prairie.
Kelly Hillier, Alberta Justice.
Rodney Fong, Public Interest Commissioner's Office.
Kevin Brzezinski, Public Interest Commissioner.
Chris Awoniuk, Public Interest Commissioner's Office.
Callahoo Stonehouse, Edmonton Rutherford.
Good morning, MLA Suite, Edmonton Manning.
Good morning, David Egan, MLA for Edmonton Northwest.
And I'm Trafton Koenig with the Office of Parliamentary Counsel.
Good morning, Warren Huffman, Committee Clerk.
And we'll go online. We'll start with Nancy. Go ahead.
Good morning, everyone. Nancy Rivera, Clerk of Journals and Committees.
Okay. Member Sear.
Scott Sear, MLA for Montego Coburg St. Paul.
Ms. Petrovic.
Chelsea Petrovic, MLA for Livingston McLeod.
Ms. El Junaid.
Najwan El Junaid, the MLA for Calgary Glenmore.
And Armstrong Hominick. Oh, you're on mute there.
Jackie Armstrong Hominick, MLA for Saskatchewan-Bakerville. Good morning, everyone.
Okay, thank you very much. For the record, I'll note the following substitution: Mrs. Petrovic for Honorable Mr. Hunter and Mr. Sear for Honorable Mr. Butchenko. A few housekeeping items to address before we turn to the business at hand. Please note that the microphones are operated by Hansard staff. Committee proceedings are live streamed on the internet and broadcast on Alberta Assembly TV. The audio and video stream and transcripts of the meeting can be accessed via the Legislative Assembly website. Those participating by video conference are encouraged to please turn your camera on while speaking and mute your microphone when you're not speaking. Members participating virtually who wish to be placed on the speakers list are asked to email or message the committee clerk, and members in the room are asked to signal the chair if you want to ask questions. Please set your cell phones and other devices to silence for the duration of the meeting. That was timely. Okay, we'll deal with the agenda. Are there any changes or additions to the draft agenda? If not, would someone like to move that we accept it?
Yes.
Yeah, okay. David Aiken. Okay. Standing Committee Resource approve the.
Oh, you're going to
Yeah, I was going to do that. I was just going to read it, yeah. Standing Committee moved by Member Egan. Standing Committee on Resource Stewardship approved the proposed agenda as distributed for its June 27th, 2025 meeting. All in favor, say aye. Aye. Any opposed, say nay. Online, all in favor, say aye.
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 Any opposed, say nay. Okay, that is carried. Approval of the minutes. Next, we have the draft minutes for our December 9th, 2024 meeting. Are there any errors or omissions to note? If not, would a member like to move that? Member Yao. So Member Yao moves that the Standing Committee Resource Stewardship approve the minutes as distributed or as amended of its meeting held on December 9th, 2024. Any discussions? If not, those in favor say aye.
Aye.
Any opposed say nay. Online, all in favor say aye.
Aye.
Any opposed say nay. That is carried. Okay, so on May 13th, 2025, the Assembly approved Government Motion 73, which referred the Public Interest Disclosure Whistleblower Protection Act to this committee for review. A comprehensive review of the Act must be taken by the Committee of the Assembly every 5 years in accordance with Section 37 of the Act. Government Motion 73 directs the committee to submit its final report to the Assembly, including any proposed amendments to the Act recommended by the committee within 12 months after commencing its review. As today is the first meeting of the review, the committee must complete its work and present its final report by June 27th, 2026. Are there any questions regarding the mandate of this committee to review this legislation? Member Egan, go ahead.
Yeah, thanks, Mr. Chair. I just wanted to have some clarification as we have a mandatory 5-year review. And so when does that 5-year count start? When we start the review or when the report comes out?
Good question. Is there?
Thank you, Mr. Chair. I believe it's once it's been reported. I think Trafton might be able to. Okay. My initial thought is that it's after it's reported 5 years after that, but Trafton's going to look into it.
That's, it's only been 4 years then, according to my calendar and my fingers counting.
Yeah, I mean, I can provide a bit more of a comprehensive answer a bit later, just because I'm looking at the act right now. But
Let's check it out, because I was
Yeah.
just thinking, does it start here? Does it start
yeah,
there?
so
Right.
the wording of Section 37 of the Act is within 2 years of the Act coming into force and every 5 years after that, meaning every 5 years after that initial review. So I'm just hesitant to provide you with like off the cuff with sort of
Go ahead and check it.
specific answer, but I'm more than happy to get back to the committee and sort of indicate exactly what the timelines are. However, I would suggest that in terms of the mandate of the committee at this specific moment, it would be in accordance with what's in Government Motion 73. So that's what provides the parameters for the Assembly's instruction to this committee in terms of what it's to be doing.
Would you have that before we get to the presentation part or just after?
No, like
future
any
meeting, then.
like any good lawyer, I want to go back and verify before giving you an answer to make sure it's right. So I'm more than happy to provide something to the committee in writing. I can circulate it after this meeting. I would say I'm not sure what the if there's a particular concern behind that question in terms of whether the committee has a mandate to do this.
Well, no, it's more like the perception of the public, because, of course, if we are changing whistleblower legislation and we're somehow rushing it, or, again, I want people to know that we're here to strengthen public whistleblower legislation in a timely sort of manner and not be rushing ahead for some other reason.
Yeah, so I mean, just to provide some broad information, Section 37 provides the committee 1 year to complete the review process. So there's a full year, as I understand it, to complete the review in terms of taking as much time as the committee needs within that kind of envelope of time to review the act, receive technical briefings, meet with stakeholders, and then come up with recommendations if there are any. So the time the committee has is 1 year to complete the review.
Yeah, thank you.
Thank you. Any others? Okay, very good. So I'll just overview the review process. As committee members will recall, we completed a review of the Personal Information Protection Act earlier this year. I anticipate that our current review will follow a similar process, and I will provide a bit of an overview on how this review might work. Today is our orientation meeting for the review. We have just reviewed our mandate with respect to the statute review. The first step in the statute review is typically to undertake information gathering and engagement on the operation of the Act. This phase often involves committee receiving technical briefings from individuals who have extensive knowledge of the Act, which we will hear from the Ministry of Justice and the Public Interest Commission. Next, the committee may decide to invite written submissions from stakeholders and possibly the public to gather feedback on the Act. In that case, the committee would provide direction to the Legislative Assembly Office in terms of drafting a list of stakeholders to be invited to make written submissions on the Act. The committee would review the draft stakeholders list at a future meeting. At that meeting, the committee could also consider if it would like to receive written submissions from the public. And if it chooses to, then it could consider directing the LAO to prepare a communication plan to advertise or solicit submissions from Albertans. After reviewing the written submissions, the committee may choose to hear oral presentations from select individuals or organizations who provided a written submission. The committee may also wish to direct the LAO to conduct specific research related to our review of the Act, such as a comparison of similar legislation across comparable Canadian jurisdiction. If asked for, research items would be prepared and presented to the committee for review at a future meeting. Following the receipt of information that the committee has solicited, analysis of the information begins, including receiving summaries of written submissions. In addition, information is required. If additional information is required, the committee may request it and also ask summaries of additional information received. Once the committee has completed this information gathering stage, the committee moves to deliberations and the making of the recommendations with respect to the act that will be reported to the Assembly. All recommendations made by the committee regarding the act will be included in a final report that will be presented to the Assembly. Do committee members have any questions or comments about the review process? Okay, all right, we'll carry on. Honorable members, as noted in the statute review, the first step typically is to request technical briefings on the act from officials whose responsibility it is to administer it and who are aware of how it operates. Accordingly, officials from the Ministry of Justice and Commissioner's Office have been invited to provide technical briefings to us today, and then afterwards, committee members will have the opportunity to ask questions of the presenters. So first, I would like to ask Ms. Hiller from the Ministry of Justice to begin her presentation. You have up to 20 minutes. Please begin when you are ready.
Good morning. Thank you for the opportunity to provide a technical briefing for the Public Interest Disclosure Whistleblower Protection Act. Before beginning my presentation, I wanted to outline Justice's role in relation to this particular legislation. Pursuant to the Designation and Transfer of Responsibility Regulation, the Minister of Justice is responsible for the Public Interest Disclosure Whistleblower Protection Act. Accordingly, Justice staff such as myself are involved with any amendments to the Act. However, the Act is administered by the Public Interest Commissioner, who is an independent officer of the legislature and is responsible for investigating allegations of wrongdoing and complaints of reprisal made under the Act. Therefore, the Public Interest Commissioner is in the best position to provide submissions respecting operation of the Act. I will begin my presentation by discussing the scope of the Act, including key definitions. I will then walk you through the legislation highlighting key sections. The Act enables public sector employees to report wrongdoing in their workplaces without facing reprisal. Employee is defined in the Act to include current employees, former employees who were subjected to reprisal, and anyone deemed as an employee in the regulations. The Act applies to 4 categories of public sector bodies and their employees. 1, government departments. 2, offices, which includes an office of the legislature and the office of every MLA, minister, and the Premier. An office of the legislature is defined as the Legislative Assembly office, as well as offices of specific officers of the legislature. 3, public entities, which is defined as an agency, board or commission, crown corporation, or other entity designated as a public entity in the regulations. 4, individuals and entities designated as prescribed service providers in the regulations. There are currently no regulations establishing prescribed service providers. Part 1, Section 3, describes the types of wrongdoings to which the Act applies. The Act applies to 5 categories of wrongdoings. These are 1, contraventions of federal or provincial laws or regulations. 2, acts or omissions that create substantial and specific dangers to the life, health, or safety of individuals, excluding dangers inherent to an employee's job. 3, acts or omissions that create a substantial and specific danger to the environment. 4, gross mismanagement of public funds, assets, or services. And 5, gross mismanagement of employees through recurring or systemic bullying, harassment, or intimidation. Knowingly directing or counseling an individual to commit a wrongdoing is considered a wrongdoing as well. The Act also allows for additional wrongdoings to be established in the regulations. Section 4.1 establishes that the Public Interest Commissioner's powers and duties are subject to parliamentary privilege. The Speaker of the Legislative Assembly has authority to decide whether a matter is subject to parliamentary privilege and therefore outside the Commissioner's jurisdiction. The Commissioner and the Speaker can develop a protocol respecting how the Act applies to the Legislative Assembly, its members, and their offices. Part 1.2 contains regulation-making powers concerning prescribed service providers. Regulations can designate individuals and bodies as prescribed service providers and set out how the Act applies to them. However, no regulations have been created concerning prescribed service providers. Part 2, Sections 5 to 15, sets out the processes for dealing with disclosures of wrongdoing. The Act creates the role of Chief Officer. For government departments, the Chief Officer is the Deputy Minister. For offices, the Chief Officer is the department head. The Chief Officers of public entities are set out in the regulations. Section 5 requires the Chief Officer to create written procedures for managing and investigating disclosures by employees. The procedures must cover the matters that are set out in subsection 2. The procedures must be communicated widely to employees. The Public Interest Commissioner can review procedures to ensure they comply with the minimum requirements. If the Commissioner determines that procedures do not meet the Act's minimum requirements, he can direct that disclosures be made directly to him until adequate procedures are implemented. Section 7 allows a Chief Officer to designate a senior official to be responsible for managing and investigating disclosures. This person is referred to as a designated officer throughout the Act. Section 8 allows an employee who is considering making a disclosure to request information or advice from their supervisor, designated officer, chief officer, or the Commissioner. The Act outlines the processes that employees must follow when disclosing wrongdoings and the form that disclosures must take. An employee can make a disclosure if they have information that they reasonably believe could show that a wrongdoing has been committed or is about to be committed, or if they have been asked to commit a wrongdoing. An employee of a department, office, or public entity can make a disclosure to their designated officer by following the procedures established under Section 5 or directly to the Commissioner in accordance with Section 15.1. Disclosures must be made in writing and must include specific information about the alleged wrongdoing. The content requirements for disclosures are set out in Section 13. In brief, disclosures must describe what happened, when it happened, and who was involved, as well as any additional information that could reasonably be required to investigate the alleged wrongdoing. Section 12 deals with the unique scenario of disclosures concerning the Office of the Public Interest Commissioner. Employees of the Office of the Public Interest Commissioner can seek advice from and make disclosures to the Auditor General instead of the Commissioner. If that happens, the Auditor General can deal with the disclosure as if he were the Commissioner. Complaints about reprisals involving the Commissioner's office are also handled by the Auditor General. Section 14 provides that a designated officer can consult with the Chief Officer or request advice from the Commissioner regarding the management and investigation of a disclosure. The Act states that employees can make disclosures directly to the Commissioner even if their employer's procedures contain language that suggests otherwise, and even if the disclosure has already been dealt with under their employer's internal procedures. Part 3, Sections 16 to 23, set out the Commissioner's powers to conduct investigations into disclosures and reprisals. Section 16 establishes that the purposes of an investigation are to bring wrongdoings or reprisals to the attention of the affected public sector body, to recommend corrective measures, and to promote public confidence in public sector bodies and the services they provide. The Commissioner is responsible for investigating disclosures made to him by employees. If an investigation into a wrongdoing uncovers additional wrongdoings, the Commissioner can investigate those as well. Solicitors and Crown prosecutors cannot be investigated. When conducting an investigation, the Commissioner has broad authority to compel evidence and access information. The Commissioner can investigate disclosures made anonymously or by non-employees at his discretion, or he can refer them to the relevant designated officer. The Act requires investigations to be carried out as informally as possible, while still respecting procedural fairness and natural justice principles. The Commissioner can take any steps he considers necessary to resolve a disclosure within the affected public sector body. Section 19 provides that the Commissioner is not required to investigate a disclosure if there is a valid reason, such as the disclosure could more appropriately be dealt with under other legislation or a collective agreement. The disclosure is already subject to an investigation under the employer's internal procedures. The disclosure is frivolous, vexatious, in bad faith, or does not deal with the wrongdoing. The disclosure concerns a decision, action, or matter resulting from a balanced and informed decision-making process on a public policy or operational issue. The disclosure does not provide enough information to conduct a fair and effective investigation, or more than 2 years has passed since the wrongdoing was discovered. If a disclosure alleges gross mismanagement of employees, the Commissioner cannot investigate the disclosure unless he is satisfied that all other relevant mechanisms for dealing with workplace bullying, harassment, and intimidation have been used or considered. Once an investigation is completed, the Commissioner must prepare a report setting out his findings, the reason for those findings, and any recommendations he considers appropriate. A copy of the report must be sent to the relevant chief officer and designated officer. The Commissioner can request a body to take steps to implement his recommendations within a reasonable amount of time. If the body does not follow up on the Commissioner's recommendations, or if the body did not cooperate with the Commissioner's investigation, the Commissioner can escalate the matter to other relevant authorities identified in Section 22, subsection 5. For example, in the case of a department, to the Clerk of the Executive Council. In the case of a public entity, to the minister responsible, if any, and to the Board of Directors or the head of the public entity. Part 4 protects employees from reprisal for doing anything permitted under the Act in good faith, including making disclosures, requesting advice about making disclosures, cooperating with investigations, and refusing to participate in a wrongdoing. Reprisal means taking or threatening, or directing or counseling someone else to take or threaten any measure that adversely affects an employee's employment or working conditions. Dismissals, layoffs, suspensions, demotions, transfers, role discontinuations or eliminations, wage reductions, schedule changes, work location changes, and reprimands are all considered reprisals under the Act. Reasonable human resource management decisions made in good faith are not considered reprisal per Section 27 of the Act. The Commissioner must investigate complaints of reprisal in the same manner as a disclosure. If the Commissioner determines that a reprisal has been taken, directed, or counseled, he must refer his decision and reasons to the Labor Relations Board to determine an appropriate remedy. If the reprisal involves the Board, however, the Commissioner must determine the remedy himself. Sections 27.1 through 27.4 set out the Board's powers, duties, and privileges in determining appropriate remedies. For complaints concerning the offices of MLAs, the Commissioner must submit a report with recommendations to the Speaker of the Legislative Assembly. To avoid duplicative proceedings and double remedies, the Commissioner, Board, or Speaker can decline to deal with a complaint if it has been or could more appropriately be addressed under any other legislation or collective agreement. They can also defer an investigation or report pending the outcome of a court proceeding or other procedure concerning the same subject matter. Part 4.1, Sections 28 to 30, establish rules around the collection, use, and disclosure of information. Section 28 provides that information necessary to make a disclosure or complaint of a reprisal can be disclosed notwithstanding any other act or regulation. Similarly, Section 29.1 establishes that the Act is paramount to the Protection of Privacy Act and the Health Information Act. Despite these provisions, Section 28.1, subsection 2, requires employees to take reasonable precautions to ensure that personal information, individually identifying health information, or confidential information is only disclosed to the extent necessary to make a disclosure or complaint. Section 28.1, subsection 1, carves out some exceptions to Section 28 by specifying that the Act does not authorize the disclosure of information or documents that would disclose the deliberations of Cabinet or a Cabinet committee. Information and documents subject to solicitor-client privilege or litigation privilege are also protected. Section 30 requires chief officers, designated officers, and the Commissioner to report potential offenses to law enforcement and the Minister of Justice. Imminent risk to individuals or the environment must also be reported to law enforcement and other relevant authorities. Investigations into disclosures or complaints must be suspended while a law enforcement investigation is ongoing. Part 7, Sections 46 to 53.1 concern offenses and liability. Sections 46 through 49 establish various offenses for deceitful or obstructionist conduct. Offenses are punishable by a fine of up to $25,000 for a first offense, $100,000 for a second or subsequent offense. Prosecutions can only be commenced within 2 years of the date on which an alleged offense occurred. Section 51 limits liability for certain acts and omissions done under the Act in good faith. Section 51.1 provides that the Commissioner and individuals engaged or employed within the office of the Public Interest Commissioner can only be compelled to give evidence in specific circumstances. As mentioned, there is a regulation under the Act. It is the Public Interest Disclosure Whistleblower Protection Regulation. It defines key terms, deals with procedural matters such as timelines, limits disclosure of quality assurance records, designates public entities and chief officers, specifically in the health and education sectors, and prescribes the complaint of reprisal form to be used by individuals who are complaining of reprisal. Thank you. That concludes my presentation.
Thank you very much, Ms. Hiller. Next, we'll hear from the Office of the Public Interest Commissioner, Commissioner Brzezinski. You and your staff have up to 20 minutes for your presentation. You may proceed.
Great, thank you. We just have a PowerPoint here. Just wait till it loads. All right, good morning, and thank you for inviting me to speak with you today. And I already introduced our Chris Iwanek, who's our Manager of Investigations, and Rod Fong, our Legal Counsel. As you're aware, the Public Interest Commissioner and the Ombudsman are two separate and independent offices of the legislature. Both offices play a vital role in upholding transparency, accountability, and ethical governance within Alberta's public sector. Each office has a different mandate, and their operational work is completely separate. As Ombudsman, my role is to investigate complaints from Albertans about unfair decisions or treatment, while as the Public Interest Commissioner, my office investigates allegations of wrongdoing and complaints of reprisal. This slide shows our current org chart. The legislation governing my role as Public Interest Commissioner is the Public Interest Disclosure Whistleblower Protection Act. Our investigative team is based in Edmonton and has 7 full-time positions. The Whistleblower Protection Act came into effect in 2013 and was first amended in 2018. The Act was reviewed a second time 5 years ago, and 10 recommendations were approved by the assigned committee. To date, none of the recommendations have been implemented with the exception of a public sector survey, which was conducted by my office. I will highlight some of the results of the survey near the end of my presentation. I'll now provide an overview of our jurisdiction. Broadly speaking, the Act applies to the public sector and includes Alberta government ministries, provincial agencies, boards and commissions, school boards, and many other entities as outlined in this current slide. The primary purpose of the Act is to facilitate whistleblower disclosures and the investigation of wrongdoing in the public sector. This includes acts which may be unlawful, dangerous to the public, or injurious to the public interest. It's important to note that disclosures of wrongdoing to my office may be made by anyone or anonymously. However, the protections provided by the Act apply only to current employees or individuals who have suffered a reprisal and are no longer employees. During the previous review, my office recommended expanding protections under the Act to all individuals who make disclosures. The Act identifies officials called chief officers who are responsible for ensuring compliance with the Act in their organizations. This includes deputy ministers, superintendent of school boards, presidents of post-secondary institutions, and CEOs of provincial corporations. The Act requires chief officers to have processes in place to accept and investigate the disclosures of wrongdoing within their organization. To assist them in accomplishing this, my office provides resources and advice to support their processes. They must ensure the internal procedures on how to report wrongdoing are widely communicated to employees. They receive investigation results and are responsible for corrective actions. As leaders, they set the tone and create an environment where employees can report wrongdoing without fear of retaliation. It's the shared responsibility of my office and chief officers to receive and investigate disclosures of wrongdoing. But what is a disclosure of wrongdoing? When it comes to the Act, wrongdoing is not simply what you or I may think of as being wrong. Rather, what constitutes a wrongdoing is specifically defined in the Act and is broken up into 3 categories. The first category of wrongdoing is the gross mismanagement of public funds, assets, the delivery of public services, or employees. Gross mismanagement is conduct that demonstrates reckless or willful disregard for proper management. In other words, the Act is not concerned with minor deviations or misconduct. This is most evident when my office investigates disclosures about the gross mismanagement of employees. We've received many such disclosures, often relating to the chief officers of organizations. These investigations are complex and generally involve numerous witnesses. In some cases, these disclosures relate to interpersonal issues best managed through an organization's human resource policies. However, when misconduct is systemic and affects the organization's workplace culture, or misconduct is repeatedly left unaddressed, it can become a wrongdoing under the Act. The second category of wrongdoing refers to a contravention of a federal or provincial or regulation. While my office can investigate contraventions of law, it's subject to restrictions if those contraventions are offenses. If, during an investigation, I have reason to believe that an offense has been committed, I must report the matter to the relevant law enforcement agency and the Minister of Justice and suspend my investigation. If the matter is one involving imminent risk to individuals or the environment, I must direct the matter to the appropriate law enforcement agency or the Chief Medical Officer of Health and to the public entity responsible for the area. A third category of wrongdoing arises when acts or omissions create a substantial and specific danger to the life, health, or safety of individuals or to the environment. For example, my office released a public report regarding the inadequate medical treatment of inmates at the Edmonton Remand Centre. I found that inmates seeking medical treatment did not receive the standard of care they were entitled to. The authority in this case accepted my recommendations and made positive changes in the correctional centres across Alberta. Other allegations investigated in my office include a CEO misusing public assets for personal gain, the systemic bullying of staff by the president of a post-secondary institution, and the misuse of poisonous substances by a government agency creating a danger to the environment. Employees who make disclosures of wrongdoing must do so in writing, and the disclosure may be made within their organization and/or to my office directly. However, not all disclosures result in a formal investigation. The Act allows me to facilitate a resolution informally. My office has emphasized this option as a way to address issues promptly and efficiently. It's not always easy for whistleblowers to come forward if they feel they have information related to a wrongdoing. It takes courage. This leads me to another objective of the Act: protecting employees who make disclosures of wrongdoing. The very title Whistleblower Protection Act reinforces the principle that individuals who act as whistleblowers ought to be provided protection. Protection takes 2 forms in this context: prohibiting reprisals and safeguarding confidentiality. First, the Act prohibits reprisals. A reprisal is any action by any person, including the employer, that adversely affects the employment or working conditions of the employee for being a whistleblower complying with the Act. This may include dismissal, demotion, transfer, change of job locations, or reduced wages. If I find that someone has committed a reprisal, I refer my decision to the Labor Relations Board for a remedy. Further, I also report the findings to the Justice Minister, as committing a reprisal is an offence that is subject to a potentially significant fine. The second form of protection is confidentiality. The Act requires that procedures be put in place to protect the identities of the whistleblowers, witnesses, and alleged wrongdoers. Identities may only be disclosed if specified by other legislation for procedural fairness or if directed by the court. For individuals who participate in my investigations, the protection of their identity is extremely important. When one considers the unwanted attention that could accompany being publicly identified as a whistleblower or a witness, the reprisal provisions of the Act alone provide many with little comfort. Protecting identities has become increasingly problematic following a recent court case involving my office. In a previous investigation, my predecessor found that the leader of an educational institution grossly mismanaged employees by creating a culture of bullying, harassment, and intimidation. The leader disagreed and applied to the courts for judicial review. The whistleblower and witnesses feared that if the leader knew their identities, the leader would not only pursue them professionally, but personally as well. We were able to keep the identities confidential throughout the investigation. However, during the judicial review, the court ordered my office to disclose an unredacted record of the investigation, identifying the individuals involved. This court decision has already negatively impacted some of our investigations and the willingness of people to come forward with information. Other cases have also revealed gaps in protections for whistleblowers and witnesses, creating barriers to report wrongdoing or participating in investigations. For example, former employees and non-employees are not granted any protections under the Act. The Act also does not protect whistleblowers and witnesses from civil action. Additionally, it does not preserve the confidentiality of those individuals involved in court proceedings. By contrast, for example, Manitoba's legislation contains a provision that explicitly provides for whistleblower confidentiality during judicial reviews. Amending our Act to include similar wording would allow my office to provide proactive protection for whistleblowers and witnesses. My office's job is to ensure that thorough and fair investigations are conducted when a disclosure of wrongdoing is made. During an investigation, I'm authorized to require any person to answer questions, provide written responses, produce records, or to provide any information as needed. Failing to cooperate with an investigation by my office is not without consequence. The Act makes it an offense to withhold information, make false statements, obstruct an investigation, or destroy evidence. These offenses are subject to an initial fine of up to $25,000 and up to $100,000 for subsequent offenses. The Act also authorizes me to decline to investigate under certain circumstances. When I decline or discontinue an investigation, I must provide the reasons for my decisions in writing. I can also broaden my investigation if other wrongdoings are uncovered. After an investigation is completed, I must prepare a written report with my findings and the reasons for the findings, including any recommendations I consider appropriate. I can compel the affected entity to report back on what action they followed or proposed to follow. In the case I mentioned earlier about the remand center, the authority, which was AHS in this case, provided my office with updates regarding all of my recommendations. In cases where no wrongdoing is found, the matter is simply concluded. The whistleblower and witnesses remain confidential, and the employee remains protected under the legislation. However, when I identify issues that, if left unresolved, could later result in wrongdoing, I may still report on those issues and make recommendations. Recently, my team investigated an allegation regarding the gross mismanagement of employees. It was apparent the whistleblower reported a number of incidents to the internal executive team, but felt nothing was done about it. Ultimately, I determined that there was no wrongdoing. However, it was clear that some HR processes could have been improved. In an effort to prevent the possible development of a toxic culture characterized by bullying, harassment, and intimidation, I made several recommendations to improve the situation. And just a few other points I'd like to cover off before concluding my presentation here today. A larger goal of my office is to promote a culture within the public sector that encourages employees and management to report and remedy wrongdoings in their workplace, creating a more transparent and accountable public service. My office actively provides presentations and awareness to public sector employees and organizations. We also work to educate organizations on the benefits of effective whistleblower protection policies and procedures. As noted earlier on, the recommendations from the review conducted 5 years ago remain outstanding. However, my office acted on the committee's 7th recommendation by conducting a public sector survey to gauge awareness of our act. We found that employees lack understanding of the legislation and are unsure of whom to contact when they have a complaint. During the survey, employees received information about our office and the act and were asked why they wouldn't report issues. Their main concerns were fear of retaliation and uncertainty about identity protection. Ensuring integrity in the public service is a shared responsibility, and I appreciate the opportunity to outline how my office contributes to that goal. Finally, and for information purposes, we've included a slide which shows the number of cases we have received over the past 3 years. As you can see, our workload is considerable given the number of staff assigned to this work. And I also can provide any additional information further in terms of statistics or our survey results if the committee so desires. And so thank you, and I can answer any questions.
Thank you very much for your presentation. Now I'd like to open the floor to questions from committee members. You may ask questions of both parties. As we did with the PIPA review, we kept a list of speakers here as people made me aware, and we went back and forth, and we had a question and then a follow-up question. So I suggest that we do the same. Please let the clerk know or me if you would like to ask a question, and we'll add you to the list. Just for the purposes of the questions, it should be relative to the technical part of the presentations and not kind of like a stakeholder part of the presentation. So if we can stay on the technical side, that'll come later, but we'll stick to the technical side. So go ahead, we can start questions. Member Sweet, go ahead.
Well, thank you, Mr. Chair, and thank you for prefacing to stay within the briefing. I have lots of questions. And I would appreciate some latitude, I think. So I do want to just go back, if I start with the Ministry of Justice first, please. And we could focus on Section 7, which is the section that allows the creation of regulation for all ministries to be able to investigate. The reason that I'd like some clarity on this is that I appreciate, and I would also appreciate if the Public Interest Commissioner wants to jump in as well. So if I could get a better understanding of how the breakdown works, if the regulation allows for the ministry to create regulation around investigation, what is the relationship between PIC then and a ministry that may be also looking into a concern? So is it referred from PIC back to whoever is identified within the ministry to take forward the concern first? Or is it deemed not an investigation and then it's sent to the ministry? Like, how does Regulation 7 or Section 7 intersect with an investigation under PIC?
Are we sure we're talking about Section 7, first of all?
Or is it Section 22? Whichever section is allowing the delegation of the department to be able to start looking into the investigation, like when you're looking at whether the deputy minister starts to get involved or not.
When it comes to the application of the Act and the reg in that fashion, I would refer the question to the Commissioner's legal counsel, simply because they deal with that and it's actioned by them and not by Justice.
So when does a ministry start to become involved? I guess is the clarity that I'm trying to understand.
Right, so if a whistleblower complaint comes to our office, we'll look at the matter. We'll determine who's best suited to actually investigate the matter. Again, we have limited capacity within our office, but we try to take the more serious complaints within government departments, for example. If it's something that's better suited with the actual ministry itself, the designated officer has the ability to investigate complaints that come forward as well. so we can delegate it back to the ministry.
Can I have one more follow-up to that?
Okay, go ahead, sure.
So then how do you ensure confidentiality with that?
Designated officers have the same responsibility as we do, is to ensure that the identities are kept confidential.
Our next question comes from Member Dick. Go ahead.
Excellent. Thank you so very much, both of you guys, for the presentation. Greatly appreciate the time here this morning. Lots of questions as well. But just following up on the process of passing, I've got one question here, I think, for the commissioner, and then one for justice afterwards. Commissioner, is there responsibility of when you pass something to a ministry for them to have to go and inquire about your inquiry that you're passing to them? If you've said this doesn't pertain to me directly, I want the ministry to go look at it, is there a requirement for the ministry to follow up on that, or can they just leave that hanging? And if you start something, at what point do you leave off of that? So like you've confirmed that they've started, there's no confirmation that they've started something. Can you just walk me through that process a little?
Sure. If we were to delegate a whistleblower complaint to an authority, they would conduct an investigation, and we would ensure that investigation was completed thoroughly and met all the requirements of the Act. If it didn't, we were unsatisfied, for example, with the result, we can still investigate that matter.
Okay, thank you. Can I have a follow-up on that one? Okay, thank you for that answer. And then for justice, does the Whistleblower Act apply to all the ministries in the same way? Or is there different sections that apply to different ministries in different structure or different ways that they would move forward in that, depending upon the ministry?
I will say that there's one section of the Act for prescribed service providers to which the Act speaks to nothing whatsoever, because they are to be set by regulation, and there is no regulation outlining. So every section of the Act is not speaking currently. And I will let the commissioner speak to how they apply specifically to various.
Like, our expectation is that every designated officer would conduct an investigation thoroughly, and it should be the same. We do try to educate all of our designated officers. We have a yearly conference that Chris actually manages, and we share best practices, and we have a great website with a lot of resources. So we would hope that they would conduct investigations in the same manner.
Thank you. The next question comes from Member El Junaid. Go ahead.
Thank
Thanks for the question. And so, yes, I would agree that a lot of the recommendations that were made previously, I would hope that they would be implemented. Certainly, as part of this process, we're going to provide our written submissions and give you some context as to what recommendations I would propose. But the one in particular, and probably the most important, is protecting whistleblowers and witnesses. I think that's key. If you don't have those protections in place, then people are hesitant to come forward. And if they're facing a possibility of civil litigation after, that certainly would prevent them from coming forward. So yeah, I'm a proponent of that recommendation for sure.
Mr. Chair, can I have a quick call?
Yep, go ahead.
So I think we have a pretty robust act in Alberta in terms of the work that we do. I know that if you compare our work, Quebec has a very robust program as well, where they conduct a lot of investigations, as well as the Canadian Integrity Commissioner. But certainly, I think what's lacking in our act is certainly the protection, again, of whistleblowers and witnesses, and I think that could be enhanced. In terms of best practices, we did have a review recently by the Center for Free Expression, and that was conducted, and there were some limitations that were pointed out in terms of our act. Our processes, on the other hand, are pretty good, I would say, in Alberta.
Thank you very much. All right, our next question comes from Member Sear. Go ahead.
Thank you for that.
Yeah, I'm not overly familiar with the review periods, other than in everyone's legislation, they have a review period. I think I would just hope that with this review, that we take into consideration the recommendations that were made last time. And then, obviously, with having submissions done by my office and then other people that intervene in this process, they will provide their perspective. But I would just hope that a lot of work goes into this, and I would hope that the recommendations actually get implemented.
Follow up?
Yes.
So again, the review that was done 5 years ago, 10 recommendations were made. Of the 10 recommendations, one was implemented, and that was the public sector survey that we conducted by my office.
Sorry, I need to clarify. This goes back to I guess, not last 5 years ago, but the 5 years before that. So during the
I'm not sure about that. Chris, maybe, are you familiar?
That would have been the first legislative review that occurred 2 years after the act came into force. And there were recommendations that were made and there were changes, most notably the addition of gross mismanagement of employees. So that was one of the bigger changes. Yeah.
Right. Thanks.
Again, thank you so much for that. I appreciate it.
Okay, I just want to do some, we'll continue on here, but I just, some of the questions are revolving around asking your opinion as opposed to the technical operation of the act. And that's kind of what we're here for today. We have had some latitude, and I'm okay with that, but I just, it's kind of getting down that path where it might be dealing more with that as opposed to the technical operation of the act. So, so we'll carry on. Member Calahoo Stonehouse, go ahead.
Thank you, Chair. My question to the Commissioner, in regards to your slideshow presentation, the last slideshow talked about the 3 terms, and there was a color scheme, and I wasn't sure what the differentiation was of each color. Could you clarify that for me? Following that, in the slideshow, you also said that 34% are also unlikely to report. I'm curious to where you collected that data from.
So to answer your first question, it was a 3-year comparison of cases received. So in 2024, 2025, we had 241 cases. Of those, 114 were general inquiries. So that could be anyone from a member of the public asking questions about the act to a designated officer asking for assistance or information. 22 of the cases were allegations of reprisal. And 105, or sorry, cases, those were actual disclosures. And then 105 were allegations of wrongdoing in the calendar year.
So we're seeing a tremendous increase.
So from year to year, there's been an increase. So in 2022-23, there was 145 cases received. 23-24, 207 cases. 24-25, 241. So every year we're seeing an increase in the last 3 years.
Thank you. And the 34%,
And
where's
the
that data
30%.
collected?
Go ahead and answer that one.
We, the Commissioner's Office acted on one of the recommendations during the last ledger review, which was to conduct a public sector survey. So with support from an outside organization, we surveyed all entities, or all public sector entities, and we received over 4,300 responses. And of those responses, 34% of respondents indicated that they would likely not report a wrongdoing if they became aware of it to either the designated officer or to our office. We have further information about the results of that survey on our website.
Great, thank you. I'd like to follow up. You've mentioned multiple times that only one of the recommendations was implemented. I'm curious why 9 of the other recommendations were not implemented, and whose responsibility is it to implement those recommendations?
It's beyond our control, and I believe it falls within justice.
The question of whether to implement recommendations of a committee of the Legislative Assembly is a government decision. And so that question would have to be put to the Minister of Justice.
Thank you.
Thank you. Our next question comes from Member Yao. Go ahead.
Oh my goodness, sorry. Thank you very much for your presentation. We greatly appreciate that. I think we're all here for the same thing. We want to make sure our processes are good and valid, and make sure that we have the ability to demonstrate good governance, whether it's through our agencies and boards or otherwise, or through our government. Obviously, the whistleblower protections are an important tool in all that. By protecting the identity of whistleblowers, your office ensures safety from reprisal, as you indicated, and ensures anonymity. I guess, to the Office of the Public Interest Commissioner, what steps are currently being taken to protect the identity of whistleblowers during the investigation? You kind of touched on it, but can you just reinforce what you're doing to ensure that people out there that are listening understand the protections that are due to them?
Right, when we get a disclosure from a whistleblower, we keep that person's identity confidential. We don't share that with anyone else externally, witnesses, etc. Even witnesses, we try to keep their information confidential as well. As I mentioned, there was one court case where their identities had been revealed, but we did everything within our power to keep their identities confidential. So it is still a safe process, and we manage many disclosures per year. And it's important that all people involved in our investigations and their identities are kept confidential, including respondents. So if an allegation of wrongdoing is made against a person, it's very important for their reputation as well, if that investigation deems that it's not founded, so that we ensure that their information is kept confidential. So it is a fairly good system, but I think it could be enhanced with the Act.
Thank you.
Follow-up?
No, sir.
Okay. Next question comes from Member Calhoun Stonehouse. Go ahead.
Great, thank you. I'm curious if you could share how many whistleblower cases in the past 5 years have involved Indigenous communities, healthcare centers, or Indigenous employees, and what were the outcomes? And is there a restorative justice model or a quasi-judiciary process that includes Indigenous ways of knowing and doing? And my second question to that is, does this legislation apply to all people working on First Nations and Métis settlements? So contract nurses, social workers, mental health outreach teams, because the jurisdiction and authority between federal lands and provincial employees, I'm just curious as to how this protection will work for folks working on federal lands.
So currently, we don't keep race-based data in terms of the number of Indigenous folks that have complained to our office. Secondly, in terms of restorative kind of justice, I think we do have within our legislation the ability to informally resolve complaints. We're taking a really hard look at that and actually conducting more informal resolutions most recently. But specific to Indigenous issues, I can't really comment on that at this point because it hasn't come forward. Lastly, yes, all individuals, employees, people can actually make complaints to our office. Now, the protections are not necessarily there for non-employees. So yes, Indigenous people from all walks of life can actually complain to our office.
Okay, and I'm just curious if the protection will work for contractors who are working on First Nations or Métis settlements.
And that's the problem, as mentioned by Kelly, with prescribed service providers. So currently in the regulation, it doesn't define who they are, so therefore there are no protections for contract workers at this time.
Thank you.
Next question comes from Member Dick. Go ahead.
Excellent. I guess my question is, section 24, I think this is a justice question here for you. There's in the first section here, it just talks about good faith, and the protection is limited to those who act in good faith. So I just have a question on that. Is it motive? Does that matter? Do we check on motive before we, of somebody who is whistleblowing before determining next steps? Like, that's a significant statement that it has to be in good faith.
My memory tells me, because I am also the lawyer who handled the last time the act was amended, so I am working on my memory. But my memory tells me that this was one of the areas that the previous commissioner wanted amended, was to remove that clause of good faith.
Interesting. Okay, thank you. That sounds great. I think I would be interested in some further clarification, I guess, maybe as a committee on that. Thank you for that. I have other questions, but there's multiples others, so why don't I just turn it over to you, Chair?
Okay, our next question comes from Member Sweet. Go ahead.
Thank you, Mr. Chair. One of the questions that I do have is that, so if we saw a significant increase in whistleblower, I don't know how you want to, whatever word you want to say, but cases to contact your office. If you start to see that it's a theme, like let's say it's healthcare, and there's a lot of healthcare workers that are coming forward talking about, like, they feel like they need whistleblower protection. Is there any mechanism currently in the Act to allow you to do a review of a systemic issue or a ministry issue when you're seeing a significant increase in, per se, one set issue? Do you know what I mean?
I do. So on the ombudsman side of the house, I have the ability to conduct own motion, so cases. But on the public interest commissioner, I need to receive a disclosure in order to investigate. But if we do get a disclosure and it relates to a systemic issue, I then can make recommendations to improve the entire organization.
So just to follow up then, so I mean, we have a current issue happening in the healthcare system right now where public servants are being asked to come and disclose information for an investigation. Is there a mechanism currently to ensure that those frontline workers who are currently being asked to disclose private or public information that is confidential information in an investigation, are they being informed of their rights under the whistleblower legislation during that investigation process? Is there a mechanism within your office to ensure that that's happening?
So I guess the mechanism typically would be through the designated officer. So that person is aware of the act and the protections, but I guess the issue is whether those employees, and I don't know all the circumstances of the case, but whether those employees are invoking the Public Interest Disclosure Act. Like, I don't know that. If they were, then they have protections. If it's a system outside of the act, they don't necessarily have those protections.
Our next question comes from Member Yao. Go ahead.
Thank you so much, Chair. You know, this is an interesting job that we have as elected officials. And over the last decade, I've seen a lot of interesting things from the different agencies, boards and commissions and stuff. And discrepancies, and sometimes I've been asked the question, like, who is responsible for this or that? And it comes down to organizations staying within their lane or whether they have to interject in something. So I guess my question is, if the commissioner seizes or refuses to investigate something that you feel could be more appropriately managed under a different jurisdiction, or some organizations already have some set rules as to who investigates that, how do you determine if the investigation is warranted? And how do you decide whether responsibility should be to an alternate investigative unit that might belong to another agency, as an example? Because I mean, like, we get discrepancies everywhere. The Auditor General's example, you know, sometimes you see them in the paper insisting that something be investigated, and our understanding is it might be under someone else, or elections officer, on and on. Like, there's all sorts of discrepancies as to who should be managing the investigation of something. Can you give us some clarity on how your office manages those conundrums?
Sure. So if, for example, I determine that a disclosure involves a potential offense in a different act, as mentioned before, I would report that to the Minister of Justice. And in some cases, if it was serious in nature, and say it's being investigated by a police agency, I would hold that case in abeyance and let them conduct their investigation. That's legislated in our act. In terms of other things, within Section 19 of the act, it talks about different circumstances where I can refuse to investigate. So if it's a human resource matter or an individual grievance between two people, that's not necessarily systemic in nature and can be dealt with by an HR process. So there are a number of different avenues for me not to investigate. But if it's serious in nature, it falls within our act, then I would investigate.
Follow up? Yeah. So have you had any instances where there was that discrepancy, where there was that discussion amongst you and another agency as to how you guys manage the situation, or has it always been fairly clear cut?
Yeah, I think in previously there were investigations, and it predates me, where a number of different offices of the legislature were involved in one case in particular. It was reported as the AER file. And so every ledge office had their own lane where they investigated a particular offense. So there has to be open communication just to ensure that, you know, you fall within your own jurisdiction and your own lane. But yeah, it has happened in the past.
Next question from Member Egan. Go ahead.
Well, thank you, Mr. Chair, and thanks for the presentations here this morning. I'm just curious about the interaction between your office, Justice, and other ministries as well. Because, say, for example, I was a Minister of Education, and we did have a designated officer that might deal with someone who came forward on a whistleblowing case. And so the ministry and the designated officer that's dealing with that is part of the investigation, really. And what we've seen here, we've seen some confusion around that, let's say in the health ministry with the corrupt care issue, where it seems like their designated officers are telling them what to do and how to do it and what to say or what not to say. I certainly didn't have that problem in my ministry when I was minister, but my point is that those designated officers in the ministry are actually a very integral part of an investigation of a whistleblowing allegation. Don't you agree?
Certainly, like they are responsible for our legislation, so they're responsible for coordinating disclosures within their organization. So it's a critical role.
Absolutely. So, I mean, certainly we would not characterize those people, those designated officers in different ministries, as just being stakeholders, but rather they are integral to the investigation.
Correct. And, if I do an investigation and I report back to the ministry, the designated officer, they ensure that, and the chief officer, they ensure that the culture and the workplace and the corrective actions are actually undertaken.
Right, yeah. I mean, yeah, thank you.
Our next question comes from Member Dick. Go ahead.
Excellent. Thank you so very much. This question might be for both of you, both Justice and Commissioner. My understanding is that the Whistleblower Act supersedes most of the other acts that we have as government, if not all the other acts that we have, including would be like the Health Information Protection Act. How do these acts engage with each other? Because my understanding is this one would supersede the HIPAA Act. Can you give some color on that, on how this act might engage with some of the other ones, and also how this is structured on those kind of information and whistleblowing conversations between these acts for personal protection in these processes?
I can say that this act, the Whistleblower Act, overrides them with respect to what information can be provided or what it can say. It specifically overrides the others. This act, however, has its own built-in protections, such as solicitor-client privilege, cabinet documents, parliamentary privilege, which has to be decided by the Speaker of the Assembly. And as the Commissioner has been saying, the parts that are geared towards protection of individual identity. But the act specifically overrides the others.
Appreciate that. May I have a follow-up? Excellent. Commissioner, you mentioned just in your presentation that you had done an investigation and that it turned into more of the HR processes. And that when that takes place, sorry, I was just unclear, do you give suggestions on clarity of those HR processes so they don't come back to you again? And what is the responsibility of an ABC, for instance? I'm not sure where this was, but for that organization to take your recommendations as well. Is there a requirement for that? What authority do you have as commissioner? And also, where do you get off the train, I guess, of saying, this is no longer my jurisdiction? I can give you some suggestions. What's within your jurisdiction of this according to the act?
Right. So if I investigate a complaint and find there is no wrongdoing, but I do find there are like HR issues or processes that could be enhanced, I can make recommendations to that department, and I can ask them to follow up within 30 days, for example, if they're going to implement any of my recommendations. I can't force them to make change, but usually all the organizations that we deal with are very good to deal with, and they actually, take our recommendations seriously.
Thank you very much.
Thank you very much. Next question comes from Member Calahoo Stonehouse.
Thank you, Chair. To the commissioners, I heard in your reports, you spoke of that you will investigate the act of gross mismanagement of funds, and that you will investigate alleged wrongdoing. But I'm curious if we are seeing an incredible steady increase of claims and 9 out of 10 recommendations filled and limited capacity in your offices. how are you really building public trust?
We build public trust by investigating complaints and making, positive recommendations for change. I think that's the whole purpose of the act is to, when a wrongdoing is reported to our office, and we can make recommendations for corrective action to enhance the public service. That certainly should instill some confidence. The protections, again, that I had mentioned, that lessens sometimes the faith that they have in the act. And I think if we can strengthen those protections, I think that would certainly help people have more faith in the system.
Thank you. So strengthening the protection.
Yes.
Thank you.
Is there a follow-up, or are you
That's good. Thank you.
Okay, thank you. Next question, Member El Junaid.
Thank you. That makes sense.
Yes, so currently, we do not have anything in our regulation relevant to prescribed service providers. And that's, I think, we need some clarity on it probably moving forward. Taking into consideration, again, do we have capacity to manage all prescribed service providers, or are there limitations? And I think during this process, we certainly, within my office, will be providing you with written submissions and actually some detailed information as to which prescribed service providers would be most appropriate. So during this process, you'll certainly get that from our office.
Yeah, I mean,
Yeah, like I think
and Justice do might have a comment.
I think every person who makes a whistleblower complaint should be provided some protection. And I think we need to really define who those prescribed service providers should be in our legislation. And once we do that, then I think we can probably enhance the act. Is there anything that you want to add, Kelly?
As you said, and as I said in my presentation, the Act does allow for a regulation to be created outlining who is a prescribed service provider and therefore who is subject to the Act. That's not been done. It is subject to instruction. If Justice receives instruction to do so, we will then create a regulation.
Thank you very much. And our question, last question, I guess, Member Sweet, go ahead.
Thank you, Mr. Chair. Can we go to burden of proof, actually, and chat a little bit about the burden of proof? So my understanding is the legislation places the onus on the employee to prove on a balance of probability or the burden of proof that the workplace reprisal is a result of whistleblower complaints. And it's not actually on the employer. And so I'm wondering how we can support employees that may feel that there's been a level of reprisal if they've done a whistleblower complaint. And is it appropriate that the employee have to demonstrate the burden of proof, or should the employer not be the one responsible for demonstrating the burden of proof?
I'll answer it and then I'll have Chris probably weigh in on this. The way that our office investigates these complaints, it's kind of a shared responsibility. So as a whistleblower that comes forward, a person who's been reprised against, they would provide their evidence. We would look at that objectively. We then would go to the employer and ask them if the allegations that were made, what happened. And we would actually take into consideration what they said. So we would look at it from a balanced perspective. We don't place the onus on one person versus the other. Does that make sense?
If I just might interject. Sure. It's a balance of probabilities, not a burden of proof. So they review the evidence and determine whether it's more likely that reprisal took place or less likely that reprisal took place. There's no burden on either party. It's an analysis of the evidence. You throw things on a scale, and whether it's more likely or not, 51%, if you will.
And I appreciate that, but the employee, the person that is facing the reprisal, is the one that has to initiate. Like, I guess what I'm wondering, to clarify, so if an employee is fired because they may come forward with information, let's say, and now it's up to that employee to prove that they were terminated based on disclosure of public good, right? And I think that's what I'm trying to figure out is, should it be the employee's responsibility to have to prove that they were terminated for providing the public good and in the best interest of the public good? Or should it not be up to the employer to demonstrate that there was misconduct that allowed for that termination?
So that comes out in the investigation. So the responsibility on the person that's been reprised against has to make a complaint. So they make a complaint and they provide their side of the story. We then would, again, go to the employer and ask them specific questions about the actual allegation, and the employer that would provide us with a response. Then we look at all of the evidence that we have, and then, like as Rod had said, on a balance of probabilities, make a decision whether or not a reprisal took place.
Do you have I got a feeling you got another question there.
On this one. I guess it's about confidence, right? It's ensuring that the public sector, because I came from public sector a long time ago. And I mean, I worked in children's services, and so we dealt with significant confidential information. And the confidence in knowing that I would be protected as an employee by going through whistleblower protection wasn't necessarily there because of the fear of termination. And so when we talk about confidence and ensuring that the public sector feels confident in being able to come forward with this information, I guess the concern is that it feels like the employee has to be able to defend, and the employer can terminate you. So you lose your job and then you have to come back and try to fight for it, right? Whether that's with getting the union involved, or whether if you're outside in managerial scope, having to then go into civil to be able to defend your employment. And I think the question is there a tool within the legislation that needs to be changed to ensure that it's, you're fired, now get your job back? Or should the employer have to prove that termination is valid before termination can occur, if that makes sense?
Mm-hmm. Chris?
So the only expectation on the part of an employee, especially in the circumstance you described, a reprisal has occurred, is for them to make a complaint to our office, right? They don't have to gather evidence. They don't have to prove their case. They just need to simply explain that they made a whistleblower complaint and they believe they were punished for doing so. The responsibility is then on our office to investigate it, and that includes gathering evidence, right? Securing email, securing records, questioning people, sometimes conducting forensic analysis of electronic data. They can be quite extensive investigations. So I'm cautious about the idea that there's an expectation on employees to prove their case, right? It is our responsibility to conduct an investigation, and then the commissioner's responsibility to balance that evidence and determine on a balance of probabilities what more than likely occurred.
Thank you very much. That's it? Okay, good. All right. No, does anyone else? No, we're good. Okay. I'd like to thank our guests from the Ministry of Justice and Office of Public Interest Commissioner for attending and providing technical briefing this morning. You're welcome to stay if you want, but if you need to leave, feel free. Thank you very much. Okay, honorable members, it is customary to invite officials from relevant ministries and offices to also provide ongoing technical assistance to both the Legislative Assembly Office and the committee throughout the reviews of this kind. I'd like to open the floor to any comments, questions, or motions in relation to inviting ongoing technical assistance from both the Ministry of Justice and the Office of Public Interest Commissioner. Member Dick, go ahead.
I got a motion here, Chair. That in support of the committee's review of the Public Interest Disclosure Whistleblower Protection Act, the Standing Committee on Resource Stewardship invite officials from the Ministry of Justice and the Office of the Public Interest Commissioner to provide A, provide technical assistance as required to the committee and Legislative Assembly Office, and B, attend meetings of the committee when requested in order to provide technical expertise.
Any discussion? Good. I'll go to the motion then. All in favor, say aye.
Aye.
Any opposed, say no. Online, all in favor, say aye.
Aye.
Any opposed, say no. That is carried. Good news. The efficiency of our LAO staff has been able to figure out the 5-year question. So I'll ask Mr. Kodak to. Yeah.
I know, it's amazing, hey? I didn't want to overpromise and underdeliver, but with the able assistance of House Services, I've been able to go back and look at the review history of this act. So what I can confirm for the committee is that all provisions of the act were proclaimed in force as of June 2013, pursuant to Order in Council 117/2013. 2 years later, the first review occurred in June 2015 pursuant to Government Motion 12, and that review was undertaken by the Select Special Ethics and Accountability Committee. 5 years after that, the act was reviewed again as of June 2020 pursuant to Government Motion 22. And that review was undertaken by this committee. And then 5 years after that, it was reviewed now, this time pursuant to Government Motion 73. So to go back to the original question earlier in the meeting by Member Agan, I would suspect the confusion may be arising because the final report of the review last time was submitted in 2021. However, pursuant to Section 37 of the Act, the counting begins when the Act was first brought into force. 2 years after that, and every 5 years subsequent to that, which is why the referral occurred now in 2025. So the short answer to the question is no, this review is not happening early. It's happening in accordance with Section 37.
Thank you. Okay, research services. So typically at this point in the statute review committees, we request research documents to assist them in their review. So with regards to stakeholder list, as I noted earlier, the common practice committees undertake during a statute review is to seek out information from relevant stakeholders. Typically, the committee will choose to direct research services to put together a draft stakeholders list for the committee's review at a future meeting. Are there any comments, questions, or motions in relation to requesting preparation of a draft stakeholders list? Member Dick?
Chair, I got a motion on this. And my motion reads that the Standing Committee on Resource Stewardship direct the Legislative Assembly Office to prepare to prepare a draft stakeholder list as part of its review of the Public Interest Disclosure Whistleblower Protection Act and distribute it to committee members for their review.
Okay, any discussion? Okay, I will go to the question. All those in favor say aye.
Aye.
Any opposed say no. Online, all those in favor say aye.
Aye. Aye.
Any opposed say no. Thank you, that is carried. Okay, cross-jurisdictional comparison is also common in reviews of this nature to task the Legislative Assembly Office with providing a cross-jurisdictional comparison document outlining similar legislation in other jurisdictions of Canada. Does anyone have thoughts on this? Okay, go with Mr. Dick.
All right, I have a motion on this too. That in support of the committee's review of the Public Interest Disclosure Whistleblower Protection Act, the Standing Committee on Resource Stewardship direct the Legislative Assembly Office to prepare a cross-jurisdictional analysis of select jurisdictions with similar public interest disclosure legislation.
Okay, is there any discussion on that? Okay, I'll go to the question. All those in favor say aye.
Aye.
Any opposed say nay. Online, all those in favor say aye.
Aye. Aye.
Any opposed say nay. That is carried. Okay, honorable members, are there any other matters at this time the committee would like to consider in relation to gathering research as part of our review of the Public Interest Disclosure Whistleblower Protection Act? Okay, Member Sweet.
Thank you, Mr. Chair. I do have two motions that I would like to bring forward. The first motion being that the Standing Committee on Resource Stewardship invite, as part of the committee's review of the Public Interest Disclosure Whistleblower Protection Act, officials from the Ministry of Hospital and Surgical Services and Primary and Preventative Health Services to present with respect to the operation of the Act at an upcoming committee meeting. I think we clearly heard today, Mr. Chair, that the ministries do have a tool and a mechanism within the Act that they are required to, as designated officers, to implement when working with public sector workers outside of the scope of stakeholder relations and being able to provide stakeholder feedback. They enact the Act within their ministries. And so I would request that that the two new ministries of health be asked to come and give us a technical briefing about how it is that they're working within the Whistleblower Protection Act within their ministries as delegated by PIC.
Any discussion? Member Dick, go ahead.
Excellent. Well, thanks to the member opposite for the motion. I'm a little surprised you brought this one forward, honestly, as a pretty experienced member of the legislature. I think we just made a motion that we would put together a draft stakeholder list. That's the time to bring these type of questions forward. So I think this motion is jumping the gun significantly. We need to get that draft list in. So I don't believe this is the right time for this motion to be in process. So I think we should vote no on this here today.
Member Egan, go ahead.
Well, thanks. And I think that we heard from Kevin Brzezinski here today that there is a fundamental difference between a stakeholder and people who are actually executing the pursuit of a whistleblower case. And we don't have to look any further than the Ministry of Health at this point right now with the corrupt care scandal, where you have allegations of people reaching in from the ministry to pursue a whistleblower allegation and being part of that investigation. So, stakeholders are one thing, but actually executing the legislation is another thing. And we heard from the Kevin Brzezinski loud and clear here today that, they're not just stakeholders in each of the ministries, but rather they are actually part of the investigation. And so, as I provided an example from when I was Minister of Education, you had a presiding officer, a designated officer that was charged with pursuing these things, and that's completely different from a stakeholder. So I think that would be worthwhile. You know, the member from Edmonton Goldbar chose two of the health ministries, and I think that's a very appropriate choice at this point in history.
Okay, any others? Go ahead, Danny.
No, I have to agree with my colleague. I think my good friend from across the aisle has right intention to bring in stakeholders, including from the ministries. And that venue is available to us. They are still considered stakeholders. That's the venue where we can ask them all the questions that I believe the opposition would want. You respect and appreciate what they're trying to achieve here, but it will be achieved just through a regular process. So to that, I would say no to this, and but to the member opposite, that their stakeholders will get included in our discussions because they are very relevant and very important to this issue. So good intent, just wrong process. Thank you.
Any others? All right, we'll go to the motion. All those in favor of the motion, say aye. Aye. Any opposed, say no.
No.
Online, in favor, say aye.
Aye.
Opposed, say no.
No.
Okay, that is defeated.
Recorded vote, please, Mr. Chair.
Recorded vote. Recorded vote has been requested. The process for a recorded vote in committee is similar to the process for a division in the House. I will first ask those in the room who are in favor of the motion to raise their hands, and then the committee clerk will call names of those who have raised their hands and record the votes. We will then follow the same process for those who are against the motion. And if you wish to abstain from the vote, please do not raise your hand. So I'll do it in-house here first, then I'll go online. So those who are in favor of the motion, please raise your hand.
Honorable Member Egan, Honorable Ms. Sweet, and Honorable Member Calloway Stonehouse.
Those who are against it in the room here, go raise your hand.
Mr. Yao and Mr. Dick.
And those online, should I ask their names and then
Yeah.
have the camera on and then?
Yeah.
I'm sorry. Turn your camera on when you're talking, so I'll ask for your opinion and we'll go from there. So, Member Algenet, go ahead. In favor? Okay. Member Petrovic, go ahead.
Opposed.
Member Sear?
Opposed?
Member Armstrong Hominick?
Opposed.
Okay. That is 5-4. That is,
Sorry.
That's okay.
And I just note for the record that Ms. Algenet raised her hand in favor. So for the motion, that's okay. For the motion, we have 4, and against, we have 5.
So that's defeated. Okay. Okay, other motions. Member Dick, go ahead.
I have another motion here. It reads that the Standing Committee on Resource Stewardship direct the Legislative Assembly Office to prepare a summary document of any significant law case or any significant case law in Alberta related to the Public Interest Disclosure Whistleblower Protection Act since 2015.
All right, is there any discussion on that? Or would you like to make a case for it, or?
Let's just leave it on the floor, see if
Okay,
anybody
fair
wants
enough.
to fight
All
it.
right. Any discussion? Okay, if there's not, I will go to the question. All those in favor say aye.
Aye.
Any opposed say nay. Online, all those in favor say aye.
Aye.
Any opposed say nay. That is carried. Any other motions? Member Sweet, go ahead.
Thank you, Mr. Chair, and I appreciate that the last motion in regards to bringing ministry officials was defeated by the government, but I am going to bring this one forward. That the Standing Committee on Resource Stewardship invite, as part of the committee's review of the Public Interest Disclosure Whistleblower Protection Act, officials from the Ministry of Treasury Board and Finance to represent with respect to the operation of the Act at an upcoming committee meeting. And just to motivate the reason behind this, Mr. Chair, is that Treasury Board and Finance now holds the public service under their mandate. There used to be a Ministry of Labor. There is no longer a Ministry of Labor. I would be inviting them. which clearly is the employer of all of the public service. They are the hirers and the firers within the public service. And they work within the requirement and the mandate to be able to ensure that employees are aware of their rights as employees when it comes to whistleblower protection, as well as anti-harassment policies, as well as labor relations in regards to the labor board, and I could go on and on. They are not a stakeholder, they are the employer. And so this Whistleblower Protection Act is directly related to the relationship with the public sector. And Treasury Board and Finance, as the employer, holds a responsibility to ensure that this act is being held and is being supported with the public sector, and that frontline workers are aware of their rights as employees. And so they do need to attend. And again, I do not believe that ministries are stakeholders. I appreciate that the member opposite said, as a seasoned person who has been in this role for over 10 years, that I should know how this works. I do. I have invited ministries before, not as stakeholders, but as ministries, because they are the government. And they do come as ministries and not as stakeholders. I could pull Hansard, I'm sure, with me putting these motions forward repeatedly over my decades of experience. So the government can choose to interpret stakeholder to ministry as the same, but tell a minister that he's a stakeholder, and I would love to see their response, Mr. Chair.
Any comment? Member Dick, go ahead.
Sure. I'm just going to go back to my original comments here too as well. We have opportunity in this we've already put a motion forward to bring forward a stakeholder list put together by the LAO. I think that is a wonderful mechanism in order for us to move forward. This is also our first meeting. This is not a normal motion to put forward in our first meeting to invite departments to the committee table. That isn't a normal procedural thing. We'd be vastly breaking historic precedent. I don't know if we need to do that in this meeting here today. And we will be getting a comprehensive stakeholder list, and it will be developed and put forward in an upcoming committee meeting. So I think this one, once again, I don't think we need to, I think we should vote no on this one. Vote no on this one, as there will be opportunity in that future draft list to talk about various other stakeholders in this.
Thank you. Any others? Member Egan, go ahead.
Yeah, thanks, Mr. Chair. And, again, we need to look at this not just as words, but with meaning as well. And the meaning of differentiation between a government presentation and a stakeholder is that the government is responsible for these things. And we didn't have to look any further than that we had the Ministry of Justice here presenting as a responsible part of this legislation. Stakeholders come because they are, representing clients, or they're individuals, or they might be labor associations and so forth, and we want all of those too, of course. But you don't lump in ministries as stakeholders. They are the government, and they are responsible for the legislation. So to somehow say that, we'll just put them all into the stakeholder presentations, I think is shirking the responsibility that the government has to whistleblower legislation.
Any other comments? Okay, if not, we'll go to the question. All those in favor of the motion in the room, say aye. Aye. All those opposed, say nay.
No.
All those online in favor of the motion, say aye.
Aye.
All those opposed, say no.
No.
It is defeated.
Recorded vote.
Recorded vote, okay. Should I read it again? Okay, we will, all those in the room that are in favor of the motion, please raise your hand.
Honorable Mr. Egan, Ms. Sweet, and Member Callahus-Stonehouse.
Those opposed in the room, please raise your hand.
Mr. Yao and Mr. Dick.
Now, to do the procedure properly, I'll ask the clerk to identify the individuals, and if you could verbally say yea or nay, we'll go on that.
Thank you, Mr. Chair. Ms. Algenay.
I support the motion. Aye.
Thank you. Mr. Sear. Thank you. Ms. Petrovic, Mrs. Petrovic,
Opposed.
and Ms. Armstrong-Hominick.
Opposed.
Mr. Chair, for the motion, 4, against 5.
Okay, that motion is defeated. Are there other motions? We are good? Okay. Okay, is there any other issues to be discussed at today's meeting? If not, at the call of the next meeting will be at the call of the chair. And if there's nothing else for the committee's consideration, I'll call for a motion to adjourn.
You're here.
Remember, all in favor of the motion, any discussion, I guess? All in favor of the motion, say aye. Any opposed, say no. Online, all in favor, say aye.
Aye.
Any opposed, say no. That is carried. Thank you very much, and the meeting is adjourned.